The clock above the bench read 9:41, and the bailiff was already counting down the hours when Dana Voss carried her 2 cardboard boxes through the courtroom doors. She walked past the prosecution table, 3 lawyers, 2 paralegals, a cart of binders, and set her boxes beside the lone wooden chair at the defense table. The man sitting there did not look up. His wrists were cuffed. His shirt was the kind of pale blue that meant the county had run out of better shirts. His name was Marcus Reyes, and by 4 o'clock the jury would either send him home or send him to a prison he had not earned. The judge entered, and the gallery rose. Judge Eleanor Tenley took the bench without ceremony, glanced once at the clock, and looked at Dana over reading glasses that did not flatter her. "Counsel for the defendant, you are new to this case." "Yes, Your Honor." "How new?" 11 days, Your Honor." The lead prosecutor, Whit Brennan, did not hide the smile pulling at his mouth. He had tried this case the first time, before the appellate court vacated the conviction. He had tried it for a year. 11 days, his smile said, was a courtesy to the calendar. "The court is aware," Judge Tenley said, "that Mr. Reyes's prior counsel withdrew under circumstances I will not air in open court. The court is also aware that the state has objected to any further continuance, so we will proceed. We will reach a verdict today. I will not break this jury again." She tapped the bench once, a small, precise sound. "Closing arguments at 1. Charge at 2. Verdict by 4. Are we clear?" It was not a question. "Yes, Your Honor," Brennan said. "Yes, Your Honor," Dana said. Her voice held. Her hands, under the table, did not. The state called Detective Lyle Merrick to the stand. He came up the aisle as if the aisle were his. A senior investigator, 26 years on the job, broad through the shoulders, gray at the temples, an open-collared shirt under a charcoal jacket. He did not look at Marcus Reyes. He had not looked at Marcus Reyes for 2 years. He was the man whose statement had put Reyes in a courtroom the first time, and his testimony clean, certain, unwavering, was the spine of the state's second try. Brennan walked him through it gently. The convenience store, the shooter in the gray hoodie, the eyewitness who had seen the hoodie come down, the detective who had taken that witness's identification and built the case from there. Merrick spoke in even, measured sentences. He used the witness's name the way a teacher uses a student's. He called Reyes the defendant without inflection. The jury watched him and seemed to settle. At 11:14, Brennan said, "No further questions," and sat down. Judge Tenley looked at the clock. "Cross-examination, Miss Voss." Dana stood. She had 11 days of file in those 2 cardboard boxes, and she had read every page twice. She had not slept the night before. She had a yellow legal pad on which she had written, in pencil, 3 lines. She did not look at the pad. "Detective Merrick, good morning." "Good morning, counsel. You spoke with the eyewitness, Miss Halloway, on the night of the incident." "I did." "You spoke with her again the following morning." "I did." "And again 4 days later." "I did." In each of those 3 conversations, Miss Halloway said the shooter wore a gray hoodie pulled up over his face. "That's correct." In the first conversation, she said she could not see his face. "I would have to check the report." "You wrote the report, detective." "Then yes." In the second conversation, she said she could not see his face. "Yes." In the third 4 days after the incident, she identified Mr. Reyes from a 6-photo array with 90% certainty. "That's correct." What changed between 4 days and 4 days? Brennan was on his feet, argumentative. "Withdrawn," Dana said before the judge could rule. "Detective, the photo array on the 4th day, who composed it?" "I did." "You included 5 other men of similar age and complexion to Mr. Reyes. Standard practice." "You also included a photograph of Mr. Reyes, taken when?" A small pause. 3 seconds. "The first." "The booking photograph from his prior arrest." "His prior arrest for what, detective?" "A possession charge. Misdemeanor. 6 years before this incident." "Yes." "Of the 6 photographs in the array, how many showed a man at booking?" The clock above the bench was 11:22. "1," Merrick said. "1," Dana repeated. She let the word sit. The juror in seat 4, a retired bookkeeper, gray bun, hands folded, wrote something on her notepad. Dana saw her write it and did not look at her again. She moved to the next line on the pad she still had not consulted. Detective, Miss Holloway told you, in the second interview, that the security camera over the register had been recording that night. She did. You retrieved that footage. I did. You watched it. I did. In your report page 11 of the supplemental, you wrote that the footage was, quote, of insufficient quality to identify the suspect. Correct. You did not tag it as evidence. I logged it. I did not submit it. You did not submit it to the prosecution. It was not probative. That was your judgment. Yes. You made that judgment 4 days before the photo array. A pause. 2 seconds. The second. Yes. Dana walked to the defense table. She did not look at Marcus Reyes. Marcus Reyes did not look up. She lifted the lid of the second cardboard box and took out a slim manila folder. She did not open it. She carried it to the lectern and set it down beside the legal pad. Detective, I'm going to ask the clerk to mark this as Defense Exhibit 4. Objection, Brennan said, already standing. Foundation, counsel has not laid any. I'm laying it, Dana said. Detective Merrick, do you recognize the form on the cover of that folder? He squinted from the witness box. He had 30-foot eyes. He saw it. It appears to be an evidence chain of custody slip. For what item? I can't read the case number from here. I will represent to the court that the case number is the case number of this case, Detective. Do you recognize the signature in the second box? The third pause. 5 seconds. Long enough that the juror in seat 4 lifted her head. Long enough that the bailiff, who had been watching the clock, looked at the witness instead. It looks like my signature. It is your signature, Detective. Defense Exhibit 4 is the chain of custody slip you signed when you retrieved the security footage from Pine and 9th on the night of the incident. The slip shows the disc was logged into the evidence locker at 23:47 hours. The slip shows it remained there. The slip shows you signed it out, alone, 6 days later. The slip does not show it being returned. Objection, Brennan said. Counsel is testifying. Sustained as to form. Ms. Voss, ask a question. Detective, where is the disc now? The fourth pause. This one was not measurable in seconds. It was measurable in a man. I do not know. You signed it out, and you do not know where it is. That's correct. Did you watch it again before it was lost? I do not recall. Detective, look at the woman in seat 4 of the jury box. Look at the man in seat 3. Look at any one of them. Did you watch the security footage from Pine and 9th a second time before it was lost? He looked. He did not mean to, but the question pulled his eyes the way truth pulls a magnet. He looked at the juror in seat 4. The retired bookkeeper looked back without expression. Yes, Merrick said. And what did you see? The fifth pause. Merrick's hands were on the rail of the witness box. He had broad, capable hands. They were white at the knuckles. Counsel. Detective. I. He drew a breath that the gallery heard. The court reporter's fingers had stopped, because there was nothing yet to record. Judge Tenley said, very quietly, Detective Merrick, answer the question. 26 years of pride is not a small thing. It does not break the way a lie breaks. It breaks slower, and it breaks first, and then the lie comes after it, because the lie has nowhere left to stand. Merrick looked at Dana Voss, and Dana Voss did not look away. And somewhere between his eyes and hers, the thing inside him gave. The footage was clearer than I represented. The juror in seat 4 wrote that down. Could a face be identified? Yes. Was that face Mr. Reyes? No. Buddy 7 W's. The courtroom did not move. It was the stillness that comes when 40 people understand, in the same heartbeat, that the floor of the room has just been changed under them. Why did you not submit the disc to the prosecution? I had built the case on Miss Holloway's identification. I had named a man. I told myself the footage was ambiguous. I told myself an array would settle it. His voice was not the voice he had brought up the aisle. I composed the array using a booking photograph. I knew what I was doing. And the disc. I lost it. A small, terrible smile. I lost it. On purpose. I told myself I had not. Brennan was on his feet. He had to be. He had no motion to make, and he made none. He stood because sitting would have been worse. Judge Tenley looked at the clock. It read 11:51. We will recess until 1. Counsel, in chambers. Detective Merrick, you will remain in the courtroom. Bailiff. The bailiff stepped to the side of the witness box. He did not put a hand on Merrick. He did not need to. Merrick sat where he was, and his hands did not leave the rail. In chambers, with the door closed and the court reporter still taking record, Judge Tenley did not raise her voice. She did not have to. She instructed Brennan to confer with his office about the disposition of the indictment. She instructed Dana to prepare a motion to strike the witness's testimony in its entirety and a motion for judgment of acquittal. She instructed the clerk to issue a referral to the district attorney's public integrity unit and to the state's professional standards board regarding Detective Merrick's testimony as given on the record. She did not use the word perjury. She did not need to. The court reporter's fingers moved without sound. Brennan tried, once, to suggest a mistrial. Judge Tenley let the thought finish before she answered it. Mr. Brennan, the remedy for the state's failure to disclose exculpatory evidence is not a mistrial that hands the state a third try at this defendant. The remedy is the one the rules describe. We will use that one. Brennan went out without speaking. Dana sat for 1 minute after the door closed. She had a motion to draft in 43 minutes. Judge Tenley looked at her. Miss Voss, you will receive attention for this. You will not enjoy most of it. Do the work in front of you. Do not read what is written about it. Go and draft. She went and drafted. The motion to strike ran 3 pages. The motion for judgment of acquittal ran 2. She filed them at 12:56. She did not eat lunch. At 1 o'clock, the court returned to session. Brennan rose first. He did not look at Merrick. He did not look at Reyes. He looked at the judge. Your Honor, in light of the testimony as developed on cross and in conference with the district attorney, the state moves to dismiss the indictment against Mr. Reyes with prejudice. Ms. Voss, the defense joins the motion, Your Honor. Granted, the indictment is dismissed with prejudice. Mr. Reyes, you are free to go. She paused. Mr. Reyes. Marcus Reyes looked up for the first time in 2 years. The court owes you an apology that the court cannot fully give. What can be given will be given on the record. The 2 years cannot be returned. The record will say, in black and white, that you were the wrong man, and that the people who put you here will answer for it under the rules. That is what this court can do. I am sorry it is not more. She turned to the jury. Members of the jury, you have served honorably. The case has been resolved before your deliberations, because the truth was put in front of this court, on the record, under oath, by counsel who did her work. You are excused with the court's thanks. The bailiff unlocked the cuffs. Marcus Reyes stood slowly and did not know what to do with his hands. Dana Voss put her own hand briefly on the back of his chair. She did not put it on him. He was a man, not a trophy. And she had learned in 11 days that there is a kind of dignity you do not touch. Detective Merrick was escorted out by 2 officers from the sheriff's professional standards detail. He was not handcuffed. He was not made a spectacle. He walked the same aisle he had walked at 9:40, and he walked it with his head down. The juror in seat 4, the retired bookkeeper, who had written down the words, "one booking photo," and "footage clearer than I represented," and "no," watched him go, and did not look pleased. She looked like a woman who had seen the rules be the rules. There is a kind of vindication that does not feel like winning. It feels like the floor holding. Outside the courthouse, on the granite steps, a small wind came up Pine Street. Marcus Reyes blinked into it. He had not been outside without a transport vehicle in 26 months. His sister was there, and a man Dana did not know, and a younger woman with a baby on her hip. They did not run to him. They walked. Dana watched from the top of the steps, 2 cardboard boxes at her feet, and she did not go down with them. The work was not the embrace. The work was the record. Inside, on the second floor, the district attorney was already on a call she had not wanted to take. By week's end, Merrick would be on administrative leave without pay, his certification under review, his prior cases pulled for a second look. By month's end, the office's photo array protocols would be rewritten with the public defender's office at the table. All of it was the consequence of 11 days of work and one chain of custody slip placed on a lectern at 11:34 in the morning. Whit Brennan came out of the doors behind her. He stopped at her shoulder. He did not look at her. 11 days, he said. 11 days. You will be in this building a long time, counsel. I intend to be. He nodded once and went down the steps the other way. The clock in the courthouse tower struck 3. That night, Dana Voss carried the 2 cardboard boxes back into the public defender's office. The fluorescent lights flickered the way they had flickered for 11 days. She sat down, and she did not cry. She had not cried in court, and she did not cry here. She read the day's transcript when the court reporter sent it up at 8. She read the cross twice. The cross was the work. The dismissal was only the record of the work. She wrote, on a fresh sheet of the yellow pad, 3 words, by the book. She underlined them once. She turned off the lamp. In courtroom 6B, the bench was empty, and the jury box was empty, and the gallery was empty. And somewhere in the basement evidence room, a clerk was logging Defense Exhibit 4 into a file that would outlive every person in it. The chain of custody slip, with Detective Lyle Merrick's signature, in the second box. The slip that did not show the disc being returned. The slip that, 11 days after Dana Voss was assigned the case nobody wanted, had been enough. The clock above the bench had reached 4. The verdict had come in. It was not the verdict the state had asked for, and it was not the verdict anyone in that room had expected when the bailiff first set the deadline at 9:40 that morning. It was a verdict the law allowed and the record required, and it had been delivered, lawfully, by the book, before the deadline ran out. Marcus Reyes went home. The record went into the file. The truth, which had been in a small disk in an evidence locker on Pine and Ninth, went onto the page where it could not be lost again. Somewhere in the long building, a junior public defender walked out into a city that had not noticed yet what one woman with a yellow legal pad and 11 days had done. The city would not notice tomorrow either, but the file would notice. The file would notice for as long as files were kept. And in the slow, patient way that justice keeps a ledger, the dignity that had been taken from Marcus Reyes for 2 years and 26 days had been restored, on the record, before 4 o'clock. By the book, it was enough.